Hello everyone, my name is Shalini Nandan Singh. I'm a legal practitioner based in Brisbane and my business is Legally Shalini. I am here to have a chat to you about the current situation and dealings that you may have in relation to your service agreements, terms and conditions and your client relationships at this time. I work out of Brisbane and most of my work is done online with clients all around Australia, and my core service is around contracts for small businesses, micro enterprises and solopreneurs. I work for myself, and so I really walk the walk and talk the talk insofar as the actual practicalities around managing contracts at this time. So this is a really intense period that we are experiencing with the onset of potential lockdown and COVID-19, the stresses that our families are facing in relation to health concerns and the change that all of this is going to bring to our lives in coming months. I mean, really, things will never be the same again on so many levels. On the home front for your business, so in terms of the business that you're running and the situation that you may be facing, one of the key areas, of course, is your client relationships. Many services have had to be cancelled or postponed, and businesses are, literally facing a period of non-activity in terms of transacting with clients. However, it is now a time of reflection for business owners, of review of processes, and of thinking of different ways of doing businesses. So I'm here to talk to you about the review of one of those processes, and that is your contracts and terms and conditions and service agreements that you have with your clients. At the beginning of this period of intense, I guess, action and inaction that's happened, an impact on our businesses. What the first and a clear problem was the deluge of requests for refunds that came from clients who felt that their services were now not going to be delivered, and of course it was true. There's many events and workshops and services that could not be delivered simply because of the various conditions placed on people gathering together, and venues having to close down, and the conditions imposed on people on the extent to which interaction could occur. So what we saw, and you're all aware of this, is a massive conversation around refunds and cancellations and how they should be managed. So in the first instance, you don't have to deal with it immediately, like as soon as someone contacts you to break their contract or to cancel a service, it's not like you have to have a plan for them immediately. The immediate plan is to actually respond to them and say, look, we've received your request and we are dealing with a number of requests such as yours, so reassure them that they're not alone and that you are working towards coming up with some kind of proposal to deal with this situation, so that a loss is mitigated between the client and you, because these are very unusual circumstances of no one is to blame. There's no, the business is not to blame, and the client isn't, the customer is not to blame, the venue is not to blame. I mean, it's a case of it's really a case of where you are wanting to set yourself up so that you are in a position to negotiate, and your client is in the same headspace too, and in a position to understand that an offer to mitigate loss will be made, and that it would help enormously for all parties to actually agree on something that's going to help everybody move forward. So my advice on how to actually manage refund requests is literally to set up the conversation, to make an offer to mitigate loss, and then make that offer and attempt to negotiate an agreement. And that could be that you're postponing the event to transfer the fees from now to then, to offer a reduced refund, so that at least there is some recompense for you as much as it is a refund for the client, It could be that they transfer those fees to another service that you provide. It could be that you have decided to offer that same service online. You've added some value add products to it, and that those fees can be transferred to that service. You need to have something to offer to clients in order to either retain the funds, to transfer those funds to an event to a later date, and to keep some kind of cash flow going. So the two key things, I suppose, that's come out of this whole deluge of refund requests is A, to have options available for your client, customers, and B, to understand that it is now important more than ever that your relationships with your relationships with your clients are key. So it's one thing to have the business terms and conditions and the contracts in place. That's your platform to negotiate from moving forward. But your ability to relate to your clients, to communicate with them and to negotiate is probably the key business skill that you require right now. The other question that people have asked me is, well, what do I do with the terms and conditions that I have now? I have a couple of things to say about that. Firstly, your contract that you have now is the contract that is between you and the client. That is what they've signed up for. So if they're cancelling, according to the contract, within the time frames in the contract, and the contract stands. Now, if the time for cancellation without penalty or a request for refund without penalty has passed, then you are in that period where you need to think, okay, I have to think outside the box. How can I do this in these circumstances? Now, if your contract, many people have asked me, what about the fact that this is a force majeure, that it's an event outside everybody's control, nobody knew this was happening. Well, I want to say one thing about force majeure. Now, force majeure is an event that is beyond the control of any party, that will prevent you or hinder or delay you from performing your obligations under a contract, or delivering that service under the contract. Now, the only time you can use that clause is if it's actually drafted into your agreement, because there is actually no legal definition for force majeure. Then because of that, it's a common law notion. If it isn't stated in your contract as a force majeure clause, you can't use it. Okay. So if it is in your contract, then it can only be used under certain circumstances, depending on how it is drafted. So if a force majeure clause says that you are prevented from, if that event occurs, which could be an act of God, it could be a pandemic, it could be civil unrest, it could be war, it could be a natural disaster. It pays to have a comprehensive list in there, and now we know why. Prior to this, when you looked at that list in a contract, you kind of rolled your eyes and thought, well, when is any of this going to happen? Well, here we are today. So if it says you are prevented, then that's a fairly tight requirement, in that you virtually has to be impossible for you to ever run that event ever again or deliver that service ever again. So if you're able to reschedule it, put it into the future for a date, repurpose it in some way, offer the core of the service in a differently, but not actually substantially depart from the delivery, taking into account the circumstances, then that clause is not likely to work, because just because it's going to be a little bit more difficult to deliver, or a little bit more expensive, or you don't make as much money as you previously thought you would because of the force majeure event, does not mean that you cannot actually perform your obligations under that contract. Okay, but if your contract says hinders or delays, that force majeure event hinders or delays you from actually delivering that service or performing your obligations under the contract, that's a little bit wider, and it can be argued that the force majeure event, i.e. the pandemic, hinders or delays you from actually delivering or performing your obligations under the contract, and therefore, you know, your obligations can be suspended or removed. But this is, you have to look at the individual contract and the business and what's happening to determine how realistic that is and whether it can actually be used. And it's rare that you can pull that one off. It needs a little bit of analysis to be able to advise on that. So be very mindful of that when you are, you know, considering that clause, and it can only be used if it is in your contract. And a well-drafted one will be fairly comprehensive, but it'll also lay out what the parties need to do if an event, a force majeure event happens. And it's usually something like, you know, that both parties must do steps A, B, and C to come to an agreement that'll mitigate loss, or that, you know, neither party will be negatively impacted, or one party won't do anything that will negatively impact the other. So negotiation is always going to be something that needs, you know, to be on the table. So again, I've said it before earlier on this video, big business skill that's required now is your ability to communicate with clients, build relationships, and to negotiate. So I guess that's, you know, a really big area that I've been dealing with in the last couple of weeks. And it is about having those conversations. So when you are negotiating with clients and making different arrangements, that arrangement needs to be captured in an agreement as well. So if you are rescheduling, postponing, transferring credits or giving credit or fees or whatever, please ensure that you have that agreement with the client or the customer in writing, that that is what's going to happen, and the terms and conditions of that change. So if for some reason they're not able to attend that event, you know, 12 months from now or 18 months from now, by when can they cancel? So those terms and conditions that you are dealing with currently, you still need to have similar terms and conditions in place to inform, you know, so that the client knows what to do if their circumstances change, and by when, and what kind of penalties or grace that they can expect from you. So my other point then is that in all the changes that you're making with clients, if you are going to be delivering the same service, but it looks a little bit different, or it's delivered at a different time, whatever you have agreed to must come with updated terms and conditions. So that might be your current ones updated for this period, or it could be a brand new one just to take your transaction with your client forward until that event or that service is delivered in some time in the future. So if you have terms and conditions now that you've had for the last couple of years, what do you do with those? Well, chances are you have never had them reviewed. Many people don't. And this is a really good time that if you are not going to depart terribly much from your current business model, that you have them reviewed and updated, and you have them reviewed and updated by a legal practitioner that understands the clauses required to go into a contract, and a legal practitioner who has an interest in your business and your type of business. So you know, pick your practitioner carefully. Go with someone that is working intensively in the area and understands the kind of people you are selling to, the kind of product or service you are delivering, and understands the business space that you are working in, so that they can advise you not only on your contract, but also on how best to build the relationships and negotiation skills that you need to have up your sleeve when you need to use your contract as a platform for negotiation. So, you know, the contract is not just a piece of paper. It is really a living document for your business, and it is there to support your business and educate your clients. And that is how I recommend you look at contracts moving forward into the next couple of months and beyond. What I would say to you now too is, for all those businesses that are pivoting and taking on a new persona, likely you are rebranding or you are moving your business online to deliver your services, you know, on an online platform. This could be face-to-face coaching. This could be individual coaching that you once delivered face-to-face in your therapy rooms, or it could be a membership site where you put all your resources into a membership portal and people buy membership. It could be an online course. You could be delivering your yoga classes online. You could be providing, you know, you could be a children's activities facilitator. And now, once you used to provide these activities inside daycares and primary schools, now you need to shift those online so that they're delivered in people's living rooms. Now, that shift from face-to-face and in-person delivery to online delivery comes with its own legal obligations and requirements, because now you are no longer in the face-to-face situation, and you are, you know, pretty much beaming into people's living rooms, and you need to have terms and conditions and disclaimers in place for those activities that you are now conducting online, because it is still a transaction. People are still paying you money. There are still obligations and expectations. There is still the matter of the intellectual property that you're sharing. There is still the matter of what clients' expectations are of the service that they're receiving from you, how they can cancel a service, how they can pay for an online service, when can they expect, you know, and under what circumstances can they expect a refund for something if they're not happy, and of course consumer law requirements that need to be, I guess, understood by you and possibly stated to the customer or the client, so that they understand the business of doing business online. So if you are pivoting to online delivery of classes, if you're pivoting to online delivery of your consulting or coaching or therapy services, if you're creating a course, if you're creating a membership site, if you are opening an online shop, every transaction at the point of sale, you need to have a conversation about it with a practitioner about the terms and conditions, a legal practitioner about the terms and conditions that need to go at the point of sale. Some of these will be straightforward and others will be complex. It just depends on the type of transaction that you're planning for your business by pivoting and going online. And that goes the same for any other pivot that you do, or any other reinvention of your business services that you do. This is the time to talk to a practitioner and legal practitioner and say, hey, I'm changing my business, I'm going to do this. What are the legals that I need to think about, or what are the legal considerations for me delivering business this way? And that is the conversation where you will become aware of the disclaimers you need, how intellectual property you need to protect, licenses that you might need, the best way to set up a business that is going to be delivered this way, contractors that you might be using, agreements you might need, the policies you need on your website, the fact that you'll be needing a privacy policy in terms of use for sure, because now you're online, you'll be collecting information. These documents are critical, where to get them, how to get them, it's all very important. So this is the time, I guess, and we all have time now, a certain amount of time for those of us who are, you know, who have been impacted directly by the inability now to actually sell our services or see clients, to reflect on how it is that we're going to reinvent or repackage ourselves moving into the future. So really, that's the nuts and bolts of it. I've tried to, you know, my dealings have been on a very practical level for people, to help them with the conversations that they need to have with clients and with their suppliers, the questions that they will be asked and the responses that they will need to make. I'm also aware that there is a bit of a mindset about, you know, this is a contraction and we all need to contract, like as in hold on to our funds, be very careful where we spend our money. I've always been careful wherever I spend my money. Pandemic is no different. But it is a time where you need to spend money on your business to make money from your business. at some point in the next couple. It may not be tomorrow, it may not be next week, but you need to be preparing yourselves to be operational. And part of that is engaging and paying for services, just as you expect your services to be engaged by people and for them to pay you. That is how economies keep going. It is a transactional. You've got to give a little to get a little. You've got to give a lot to get a lot. And in coming months, there's a number of financial support and packages that are being offered to all levels of business, micro, small, companies, corporations. This is not a time to hoard that money that you received to help your business. This is the time to use that money on your business, to kickstart your business, to resuscitate your business. It's very important that you do not put that money away for a rainy day. And I'm very pleased that Laura has put this together. And, you know, there's a number of resources that she's providing to everyone to be able to feel that confidence of that it's okay to keep working on your business, just be, you know, to refine your services, to get your contracts done, to speak to your accountant, to work out ways of delivering your service at the same time, to have the solid, you know, to have solid foundations still happening. You may not have done this in your previous business or earlier, you know, 2, 3 or 5 years ago. You may have started your business on a wing on a prayer, but consider this time as a time to, okay, I'm not going to make that mistake again. This time I will deal with my legals. I will make sure my contracts are appropriate for my business. I will attend to my finances. I will get advice from my accountant. I will get advice from my lawyer, and I will make sure that these things that are, you know, that have the potential to rattle my business are dealt in the best possible way moving forward. So my final thoughts are just those, is that to keep the faith that we are entering a period of doing business differently. It's not a phase of never doing business at all, that it's a time literally for creativity, for thinking outside the box, but most importantly, never forget that your business is built on relationships with your clients and that they must always be captured somewhere on a document as a contract so that you can negotiate them from that platform anytime you need to in order to support yourself, your business and your clients. I hope this has been helpful for you, and yeah, I look forward to listening to the other resources that are provided on this platform. My name is Shalini Nandan Singh. My business name is Legally Shalini. My website is www.legallyshalini.com.au, and I invite you to contact me if you have any questions or need any assistance at all. Please reach out. Thank you.